Hello and welcome to the LLG Grapevine podcast. You're listening to Helen Bennett, LLG's Executive Director of Policy and Governance, and Dennis Hall, LLG Bulletin Editor.
Hello, everyone.
Now, this is our last podcast before we break for the summer, but it has no less information packed full of sector news and developments. But before we start, a huge congratulations to the Lionesses who won on penalties in the UEFA Women's Euro final. There was so much excitement in my house, Dennis. And we will return to football later at the end of the podcast, I believe.
Yes, indeed. Well, I must say, Helen, that we have our own interest in the game here in the Northeast with Northeast Lioness Lucy Bronze, who played her part in the game. She's from Berwick in Northumberland, right in the corner of Northeast England, and she did very well. Truly exciting game, thoroughly entertaining.
Really thrilling, yeah, too thrilling at times. But let's move back to local authority and central government. What will we discuss first?
Well, we've got to talk about the new elections bill. The government is to bring forward an elections bill together with a programme of secondary legislation that will now give 16-year-olds the right to vote in all UK elections. The bill will also expand voter ID to permit the use of UK-issued bank cards as an accepted form of ID at the polling station and close a loophole that would allow foreign donors via so-called shell companies to influence UK political parties.
Well, the Ministry of Housing, Communities and Local Government said 16 and 17-year-olds already contribute to society by working, paying taxes, and serving in the military, and so should be given the right to vote on the issues that affect them. And giving them the right to vote, of course, would bring UK-wide elections in line with Scotland and Wales, who already provide for that. Now, the plans are set out in a new strategy paper entitled Restoring Trust in Our Democracy, Our Strategy for Modern and Secure Elections.
Yes, and the ministry have said that other proposed measures would include harnessing more digital options to support both voters and polling station staff, including allowing accepted IDs such as the veteran card and the UK driving licence to be used at polling stations when they become available in digital format. A new digital voter authority certificate will also be created to ensure electoral registration officers can meet the digital needs of voters, reduce printing costs and ensure faster delivery. And the ministry claimed that an increasingly automated voter registration system would also make it easier for people to register to vote and reduce the need to fill out their details across different government services on multiple occasions.
Well, that would be nice. There will also be new requirements on unincorporated associations that mandates checks on donations over £500 in order to tackle foreign interference and protect UK democracy from those who attempt to undermine it. Now, the Electoral Commission will meanwhile be enabled to enforce heavier fines of up to £500,000 on those who breach political financial rules.
The reforms will also see tougher sentences for those who abuse election campaigners. The ministry said abusive behaviour is on the rise, particularly against women and ethnic minorities, with recent Electoral Commission research showing 55% of candidates at the 2024 general election experiencing abuse. And the government said that the reforms will crack down on these unacceptable practices, delivering tougher sentences for those who intimidate campaigners and stronger protections for candidates in public life by removing the requirement for their home address to be published and openly available.
Well, LLG have been saying that for a long time now, due to the increase in this harassment and abuse, and worse, actually. Let's take a look at what Deputy Prime Minister Angela Rayner has said in relation to this. She says, for too long, public trust in our democracy has been damaged and faith in our institutions has been allowed to decline. We, as in the government, are taking action to break down barriers to participation that will ensure more people have the opportunity to engage in UK democracy, supporting our plan for change and delivering on our manifesto commitment to give 16-year-olds the right to vote. And going on, she said, we cannot take our democracy for granted, and by protecting our elections from abuse and boosting participation, we will strengthen the foundations of our society for the future.
Responding to the announcements, Vijay Rangarajan, Chief Executive of the Electoral Commission, said, "These reforms will improve the resilience and integrity of our electoral system, tackling many of the threats it faces, and should improve the experience for voters, campaigners, parties and administrators." And going on, he said, "Registration reform would open the door for millions more to get involved in elections, and the proposed changes to the political finance rules would strengthen the checks on money coming into UK politics and ensure a more proportionate and effective enforcement regime."
Yeah, I read what he said. He also said we're ready to work with the electoral community to build understanding and compliance with any new requirements and to support voters with information and education resources. And the Commission said it supports proposals for digital voter ID, but warned that using bank cards as voter ID has risks for security and voter trust. Interesting.
Now, the Committee on Standards in Public Life also welcomed the changes, with its chair, Doug Chambers, suggesting they marked a step forward towards a more transparent, proportionate and effective framework for regulating election finance.
Have we got any timelines on this, Dennis? Do you know?
Haven't seen any published, so I think that's something that will come forward later.
Yeah, we'll pick that up when it's published. Now, I want to turn to Wales and an item in our Welsh bulletin concerning consultation to extend the duty on local authorities to broadcast meetings. Now, Wales, of course, have had remote meeting provision for years now, whilst England are still playing catch up. We're still waiting for the government to legislate. But now Wales is consulting on whether or not other meetings of the council, aside from full council, should be required to be broadcast.
Section 46 of the Local Government and Elections Wales Act 2021 places a duty on principal councils to put in place arrangements for the broadcasting of full council meetings, so that members of the public who are unable to attend in person can see and hear proceedings as they happen. Section 46 also gives Welsh ministers the power to require a principal council to broadcast other meetings it holds, and also gives Welsh ministers the power to require fire and rescue authorities and national park authorities to broadcast their meetings also. The consultation also considers whether there should be a retention period for recordings of broadcast meetings.
Well, I understand that the original intention was for all principal council meetings to be broadcast live, not just the full council meeting. However, at the time, principal councils raised concerns about their capacity to comply with this requirement and the infrastructure needed to support this approach. And the suggestion of a more staged implementation was accepted at the time. However, now Welsh ministers are keen to maximise the potential of digital technology to achieve greater transparency, collaboration and accountability between principal councils and the citizens of Wales. But Welsh ministers have recognised that it's also important not to disenfranchise individuals who do not have access to or are unable to engage with digital technology, because they still exist.
Yes, indeed. And to assist with the implementation of sections 46 and 47 of the 2021 Act, Welsh ministers have already provided more than £850,000 to principal councils to support the implementation of multi-location meetings, thereby enabling a variety of platforms and approaches to be taken based upon the circumstances of each principal council.
Well, the Welsh Government has undertaken an analysis of principal council compliance with the broadcasting duty, and that showed that all of the principal councils are broadcasting their full council meetings live and retaining a copy of the recording online for members of the public to access. And indeed, many have gone beyond the mandatory requirements of the 2021 Act and are broadcasting live or providing an online recording of other meetings, and these meetings include meetings of the Cabinet, of overview and scrutiny committees and planning committees. Now, this consultation, nice long run-up by the Welsh Government here, it closes yes. on the 6th of October, Dennis.
Yes, we've mentioned this before, haven't we, that often English government has consultations that run throughout August, which is a strange time, don't you think? October seems more sensible in this instance, don't you think?
I do, very much.
Yeah. Right. Well, now I turn to a parliamentary committee that has just launched an inquiry into the protection of human rights of children in England. The Joint Committee on Human Rights has launched an inquiry into how well the human rights of children in England are protected in the social care system. It said the new inquiry would have a particular focus on children in care, but wider aspects of the system would also be relevant. For example, in regard to kinship care, to the availability of additional support to families with disabled children, or to the efficacy of early intervention measures.
Well, I looked at this and I think it's extremely welcome. So the Committee has launched a call for written evidence covering issues such as the adequacy of the legal framework. And in this respect, it asks a number of things. A big question is, to what extent are convention rights protected in the children's social care system, particularly the right to respect for private and family life, Article 8, of course, for example, in relation to sibling separation and relocation, and the right to liberty and security, that's Article 5, say in relation to deprivation of liberty orders.
Yes, and other questions the committee is concerned with include the right to a fair trial under, of course, Article 6 of the ECHR, for example, in relation to access to justice and legal advice. Also, the protection against discrimination in the enjoyment of convention rights, that's Article 14. And finally, the right to an effective education under Article 2, Protocol 1 of the ECHR.
Yes, and the Joint Committee plans to ask, excuse me, a number of key questions. Let's take a look at those, Dennis. So
Yeah.
one of the questions is, if the UN Convention on the Rights of the Child were to be incorporated into domestic law in England, to what extent would that affect the protection of the human rights of children supported by or in the social care system?
Yes, interesting. And secondly, what would be the legal and practical consequences of making care experience a protected characteristic under the Equality Act 2010? Would you support this change, for example? And finally, from me, do any human rights concerns arise from the Disabled Children's Social Care Framework? And if so, what are they?
Yeah. Well, the call for evidence also covers accommodation for children in care, human rights considerations arising from kinship care, overrepresentation within criminal justice, training and understanding about statutory duties owed to children in care, complaints and remedies, and good practices that protect and promote human rights in children's social care systems from devolved nations and other countries.
The Joint Committee has also launched an online survey to better understand the views of those who have experience of the children's social care system in England. The deadline for written submissions to the inquiry is the 25th of August. And interestingly, early this week, the Public Accounts Committee announced that it too would be holding an inquiry into the financial sustainability of children's care homes, one of 14 new inquiries. So clearly this relates to this particular inquiry as well, Helen.
Yeah, and I wonder whether uh, England will look to Wales in that regard, because of course Wales were moving towards ensuring that any uh, children's homes must be publicly owned.
Mm,
We covered that previously
yes.
in the podcast. So
It's
um,
clearly a topic that's going to run for some time, and we will, of course, report back on what the outcomes
yeah,
from these inquiries.
absolutely. Let's take a move now towards standards, one of our favourite topics. So the government has announced that a new Ethics and Integrity Commission will be established to drive up standards in public life, delivering on a key manifesto commitment, because it was in there. And they're looking to, well, they want to overhaul, simplify and strengthen standards. Rule breaking, in respect of rule breaking, ministers who leave office following serious breach of a ministerial code should be stopped from getting severance payments. And they want the Advisory Committee for Business Appointments abolished, and financial sanctions to be introduced. So this is interesting. The body will have an ambitious remit, says the government, to uphold the highest ethical standards across the public sector.
And the government states that the Prime Minister has made clear that public service is a privilege and is committed to showing how politics can be a force for good. Since taking office last July, the government states it has made the choice to break away from the old approaches, learn the lessons from previous years, and restore trust in government by ensuring ministers are held to the highest standards.
Well, the Chancellor of the Duchy of Lancaster, who's Pat McFadden, he said that this overhaul will mean there are stronger rules, fewer quangos, and clearer lines of accountability. He acknowledged the Committee on Standards in Public Life has played an important role in the past 3 decades, and the changes give a new mandate for the future. But whatever the institutional landscape, he warned, the public will in the end judge politicians and the government by how they do their jobs and how they fulfill the principles of public life. Quite right. Ministers will give the Ethics and Integrity Commission a stronger mandate and an expanded role to help ethics and integrity, excuse me, at the heart of every public sector organisation. That's the published intention.
Yes, and its wider remit will include a new obligation to report annually to the Prime Minister on the overall health of our standards system, and a new function of regular engagement with public sector bodies to assist them in the development of clear codes of conduct with effective oversight arrangements. The government is also providing a new commitment to respond to all Ethics and Integrity Commission reports in a reasonable timeframe, following criticism that previous recommendations were simply ignored.
Well, the eligibility for ministerial severance payments will be restricted. So currently, ministers, I actually didn't know this, ministers are entitled to a severance payment equivalent to 3 months' salary when they leave office for any reason, and regardless of how long they've been in the job, even if it's just a few days or weeks. And under the new changes, ministers who leave office following a serious breach of the ministerial code or having served fewer than 6 months will forego their severance payment. Ministers who return to office within 3 months of leaving will forego their salary until the end of that 3-month period. Now, I'm sure we're going to hear a lot more about the Commission in due course, Dennis.
Yes.
So now let's return to football and go Lionesses. Couldn't resist that again, Dennis.
Well, it's inevitable, of course, and as you read this, we're still basking in the success of yesterday's tremendous final. Can't get it out of our minds, can we? But we really should for this next item because, well, we are at the start of the Premier Division football for the new season. Schools, too, will be eventually, at the end of the holidays, there'll be centres of football activity, probably with even more enthusiasm than previously as a result of yesterday's final. Everyone wants to play football now. But here's the question. When does football at school facilities amount to a legal nuisance? And more importantly, what might a court do in such cases? Now, the High Court has ruled in Bacarty against Hampshire County Council that the noise of children playing and footballs landing in the claimant's garden from a school play area did amount to a nuisance.
Yeah, it's interesting. The case centered around the defendant's construction and operation of an all-weather play area built for the primary phase of Westgate School in Hampshire, which lies adjacent to the claimant's boundary fence. Now, the all-weather play area was used for formal and informal play throughout the day and after school. It was also rented out on weekends, and it must have done well because it was generating an income in the region of £6,000 to £8,000 per annum. I can think of lots of primary schools that would love to have that kind of income.
Well, indeed, it probably will increase as a result of the Lionesses' success too.
Yeah.
But distressed by the noise and the 170 footballs entering their garden from the all-weather play area, the claimants complained and the parties entered into negotiations. Although the negotiations were not successful, the school nevertheless implemented various mitigation measures, including installing a net over the top of the play area and restricting use to school hours only. But still dissatisfied, the claimants brought a claim in the High Court for common law nuisance, seeking an injunction prohibiting any use of the all-weather play area.
I've got to say, Dennis, here that 170 footballs, that's a lot, isn't it?
It is.
And what are they smashing into when they, I mean, we've all got neighbours with kids that knock balls into the garden, and if you're a
Yeah.
reasonable person, of course, you're fine with that. I'm
Yeah,
going to
not the
say
ideal place for a greenhouse or conservatory, perhaps.
no, certainly not. So let's turn back to what the judge considered. And obviously, um, essentially, he looked. Actually, I don't know who the judge was. Apologies, but the relevant. The judge looked at the relevant principles for private nuisance, and
Yeah.
these were: one, whether the activities amount to substantial interference with the ordinary use of the claimant's land. Two, if so, whether the use complained of is part of the normal use of the defendant's neighbourhood or locality. And three, even if the defendant's use is ordinary or normal, it must still be conveniently done, taking into consideration the nature, effect, duration, and frequency of the activity.
Applying these principles, the judge found on point one that the level of noise and the number of balls going over the fence amounted to a substantial interference with the ordinary use of the claimant's land. On point two, the judge considered that the all-weather play area was a reasonable and expected use of the land in the context of a suburban residential area, featuring a number of educational establishments. Finally, on point three, regarding the convenience of the all-weather play area with both parties' interests in mind, the judge held that the installation and operation of the play area was, in his words, conveniently done.
So the judge concluded that an injunction was not appropriate. The claimant was awarded damages of £1,000 to compensate for the nuisance suffered during the 10-month period in which the all-weather play area had been used at the weekends. And the defendant also gave a general undertaking to use the play area during school hours only.
It's an interesting one, this, isn't it, Helen? The judgment serves as a useful reminder of the importance of mitigation when faced with a potential nuisance claim. Now, while the claimants were technically successful in establishing nuisance, the injunction the couple sought was not granted, as the mitigations had largely remedied the nuisance. The case balances private property rights with community benefit and reinforces the point that nuisance is a fact-sensitive, context-driven inquiry. Helen, that case sounded like a score draw to me. What do you think?
Oh, I think you shouldn't give up your day job, Dennis. That's what I think.
Might have to go to penalties.
Oh no, I don't think I can live through penalties
No, I
again.
couldn't.
Not anytime soon. Unfortunately, it's our last item today. um, so taken from the Law Gazette, actually, this is really quite concerning. There's a damning new report which has said that the legal profession is failing on multiple levels to address diversity issues and could even be in breach of lawful duties to protect minorities. Now, this is the Legal Services Board, and they've said that there's a clear case for intervention based on the persistent gaps in diversity and factors holding back change in the profession. Evidence from frontline regulators and wider analysis of the sector has identified deep-rooted systematic barriers to equality and diversity.
In a paper which was presented to the Legal Services Board, the LSB centres on obscured and inaccessible pathways into the profession, including financial hurdles and the elitist attitudes regarding the image of a lawyer. Women, minority ethnic groups and disabled lawyers remain underrepresented in the law, particularly at senior and management levels, while bullying, harassment, discrimination and other forms of behavioural misconduct are particularly prominent.
Well, the Legal Services Board's proposals to address these issues is a new statutory policy statement, and that'll be issued to every frontline regulator with 4 specific outcomes. Now, we haven't, I have to say, we haven't had sight of this report. This report is being referred to by the Law Gazette. It's not published by the Legal Services Board yet. I think they took a report to one of their committees. So we have to wait for the statutory policy statement to be actually published to see what these outcomes look like. But the chief executive of the Legal Services Board, Craig Westwood, has incidentally now stepped down from the organisation, having tendered his resignation, citing personal considerations. And Richard Orpin, who's the Director of Regulation and Policy at the LSB, he's been appointed interim CEO. So there's obviously a lot of changes going on at the Legal Services Board, Dennis.
Yes.
But we'll keep a lookout for that report, because that those findings are deeply concerning. We've always been a big advocate at LLG of not just EDI, but social mobility as well.
Indeed, Helen. You know, it does shine a light really on something that is really, really disturbing. And I do wonder how effective some of the organizations, particularly the LSB, feel that they've been on this. I think that raises a question about the role of some of these bodies.
Yeah, I agree. And on that note, that's it for another edition of the podcast. It's our last before the summer break, but you can read more on the items discussed today and many more besides by going to bulletin number 28, available on the LLG website now. So it's goodbye from me.
And from me too. Bye now. Have a good summer.